right? There is no exclusive sovereignty. There is overlapping sovereignty even within our domestic system before we look overseas between the states and the federal government. Sometimes things will be in the more or less exclusive domain of one or the other, but quite often there is overlapping sovereignty where both the states and the federal government have some claim to authority. People will also talk about aspects of external sovereignty, that is, sovereignty as against other nations, and the sort of robustness of borders in preventing incursions by outsiders into the affairs that occur within one's borders. The question is, why ought we be concerned with that, particularly given that many things outside one's borders will have an effect within it, regardless of any kind of formal governmental structures, but in a world where trade ties and ties of commerce and culture will often transcend borders. No country is an island. One thing which I think some of our panelists, I know John's McGinnis's comments will touch on this, has to do with the idea of sovereignty as kind of a proxy for democratic accountability, and the concern that legitimate government, as the government created by our Constitution, rests on the consent of the governed and some input from the governed into the processes of government and the setting of rules. And from that perspective, the delegation of authority to international bodies that may not be directly elected or may not be democratically accountable can be troublesome. And this creates an inherent tension, especially to the extent that certain international agreements or bodies are set up precisely for the purpose of restricting a nation's ability to later engage in democratic decision-making. So just to take the example of free trade agreements, right? Most economists would agree that free trade, the elimination of tariffs, and the ability of countries to trade with one another is economically desirable, is something that in a free market system we would consider desirable. And when countries enter into a global free trade agreement, like the WTO and the GATT, or like NAFTA, one of the purposes is to sort of tie themselves to the mast against later political winds of protectionism, right, where particular domestic industries later on, the steel industry, for example, might say, well, you know, it would be in our interest to have protectionist tariffs. And they might lobby their lawmakers to impose those tariffs and so on. In one sense, imposing those trade restrictions would be the sort of will of the Democratic majority, and yet at some antecedent moment in time, the majority has also decided that it's better to engage in some kind of long-term commitment that will inhibit those later majorities from engaging in the decision-making they want. And in a certain sense, there are parallels to constitution-making, but many of the same concerns about the democratic deficit of courts and bodies that enforce constitutions actually come into play, but in quite different ways when you have not a domestic institution that is accountable to the people of a particular polity, however indirectly, but to an international institution with members from many different countries that might be exercising that authority. So those are some thoughts to begin our discussion, and I hope we can come back to this question of what exactly is sovereignty and why ought we be concerned about it as we consider whether international bodies threaten this magical concept. With that, I'll turn first to Oona.
So I'm going to stand up here so I can actually see my own slides. I wasn't planning on doing slides, but then Stephen did PowerPoint yesterday, and I decided the lawyers couldn't let themselves be outdone by the social scientists. So I put these together after dinner. Hopefully they'll be coherent. So the question that we've been asked to address today is, do international bodies threaten sovereignty? And this is a tough question to address, in part because it raises some definitional questions right off the bat. What are international bodies? What is sovereignty, as Jenny has already said? And I started thinking about sort of what is it that motivated this question. In some of this, there's some kind of extreme rhetoric out there about international bodies that many of us have heard. You know, some of the kind of the claims, a lot of the Sea Treaty represents a permanent loss of national sovereignty. Hence, it's inherently un-American, which is actually kind of really the point Jenny just made, this idea of sovereignty as a challenge to democracy. the claim that just as Hurricane Katrina ruptured the levees protecting New Orleans, the concerted UN assault on the barriers to further erosion of American sovereignty threatens to swamp our freedom of action. These are the kinds of kind of rhetorical claims that we sometimes hear about international law, particularly when we look at the popular press and politicians. But I think we want to take a step back from that and ask, what are these international bodies? What do they really do? And then with that in front of us, the reality of what international bodies are, how they're created, what they actually do, then ask the question, do they threaten sovereignty? So first, what are international bodies? At least this is how I think about the question. So international bodies, as you all probably know, are usually created by a treaty to administer legal rules announced in the treaty. So examples include the United Nations, created through the UN Charter, the World Trade Organization, created through the latest round of the GATT, the Committee on Torture, the European Court of Human Rights. These are all organizations created through a treaty. Now, of course, a key element of this is that in general, the only states that these bodies are able to act on or that have authority over are those states that have voluntarily joined the treaty itself. And so there is a moment of consent that gives the authority to these international bodies to act on the states. So this is a part of the conversation that I think is just really important to get right at the very beginning, which is that international bodies only have the authority to act because the states have given the international bodies that authority to act. Now, that doesn't necessarily mean that there aren't challenges to sovereignty. The kinds of things that Jenny has mentioned may nonetheless remain a problem. The kinds of questions about once we've joined an organization, if it starts engaging in actions that later we decide we dislike, does that pose a sovereignty threat? But we have to bear in mind that it's not that these organizations are acting on states independent of some choice by the states themselves. Now, in all but a few instances, these treaty bodies, as I mentioned, only have authority to act because the states have given them that authority. And so many of the complaints that you often hear about international bodies are actually not complaints about the bodies themselves, but complaints about the consent process for adhering to those international bodies. So I just want to be careful to separate those complaints out right at the outstart. So if the complaint is that the two-thirds clause, the treaty clause allows two-thirds of the Senate and the President to adhere to international bodies, which then have the authority to act on the United States, and that usurps the power of the House of Representatives or the states, that is a complaint not about the international bodies so much as it is a complaint about the Constitution and the domestic rules that lead us to, or give us the power to adhere to these international bodies. So when we're talking about the question of sovereignty, I think we need to separate out, is it a question of the problems with the Constitution and domestic rules for adhering to these international bodies, the treaties that create these international bodies, or is it a problem with the international bodies themselves? And some of the complaints will be directed at either of those, and I think we want to be clear which one we want to talk about. I also want to put on the table up front that we'll hear questions about delegation and questions that Jenny's already motioned towards, that once states join an international agreement, well, then that body may start, the body created by that international agreement might start doing things that are very different from what was initially understood at the time that the state consented. To which I want to remind us that in general, in nearly every case, states continue to have the opportunity to withdraw from those organizations. Most of these treaties have provisions in place that allow states to withdraw. Now, we may say that once you're in, it's harder to make the decision to choose to get out. That may be true. Again, that's a question of domestic politics more than it is a question of the international bodies. But let's bear in mind that if an organization really goes off the rails and begins to put in place policies or requirements that are entirely different from what the state understood them to be at the time that it joined the organization, it remains an option in nearly every instance for the state to withdraw. So again, I think that's something we have to bear in mind when we're thinking about this question of delegation and the challenges to sovereignty that that creates. Now, I want to take a minute to give a little bit of a plug for a new line of work that I've been doing recently with a colleague of mine, Scott Shapiro, who's a legal philosopher. We have a piece coming out. I just literally put the finishing touches on it this weekend, last weekend. It's a piece called Outcasting, the Enforcement of Domestic and International Law. And one of the arguments that we make here is that people tend to think of law enforcement as having two elements. That it sanctions its commands through physical force, and that it sanctions its commands through designated bureaucracies. The paradigmatic example is police. And we argue that there's a different way of thinking about law enforcement that has neither of these features. It neither requires the use of physical force, nor requires action through internal bureaucracies, and that is this idea of outcasting that we develop in the paper. Outcasting is a concept that involves denying those who disobey the rules of an international organization the benefits of social cooperation and membership. And let me just give an example to explain what I mean by this. So take the World Trade Organization. So how does the World Trade Organization enforce its rules? It doesn't send in the army. It doesn't send in an international police. If a state is violating the tariff rules or other rules in the GATT, what does it do? Well, of course, the state has to go through a dispute settlement process, and it has to get a ruling from the dispute settlement body that, in fact, yes, the GATT was violated. And once it has got that holding, it then is authorized to put in place countermeasures. Well, what are the countermeasures? These are measures by the very state that was harmed against the state that did the harm. What does the countermeasure entail? Really, if you think about it, the countermeasure is an authorized violation of the agreement. It's an authorized violation in that it allows the state that was harmed to put in place an equivalent violation of the agreement against the party that violated the agreement against them. So we call this outcasting because it is taking away the protection the agreement otherwise would be giving you in retaliation for your failure to abide by the agreement. That's the idea of outcasting. It creates benefits of membership, that is, access to lower trade barriers. You get access to lower trade barriers in exchange for giving lower trade barriers to others. You break that. What does the organization do? It doesn't send in the army. It allows the other party to do an equivalent violation back, to withdraw the benefits of membership in a small measure equivalent to the benefits of membership you denied them. And that's the idea of outcasting. So there's a creation of these benefits by the organization, which then are taken away by states that are non-compliant. That's the basic insight of outcasting. Once you start looking for it, it's everywhere. And the article goes into excruciating detail about lots and lots of different variations on outcasting, that customary countermeasures could be understood in this way. It allows an equivalent violation in return for a violation by another state. Economic sanctions could be understood as a form of outcasting in retaliation for your violating, say, a human rights norm. It takes away benefits in another regime. This is what we call cross-countermeasures, or non-in-kind outcasting. So we develop a whole kind of taxonomy of different kinds of outcasting. So in return for your violation of a human rights regime, you lose the benefits of protection in a certain measure of the international legal order. And so we develop a lot of different examples of this, the basic principle of which is that international law enforces not through doing things to states, but by allowing states to refuse to act with other states. And that if you see it that way, then sovereignty, the question of sovereignty, I think, is put in a different light. So to return to this idea of traditional understandings of law enforcement. So traditional understandings of law enforcement kind of put international law in a box. It says, look, either you're not really law because you don't actually enforce, or if you're really law, then you must enforce like a modern state. You have to have something equivalent to international police ready to force compliance. Well, so that puts international law in a catch-22. Either it's not really a law, or it really is a violation of sovereignty because it involves sending in the blue helmets, the sort of the boogeymen of those who worry about sovereignty. And what we say is, no, you have to think about it differently. International bodies create benefits for their members, and that's why states choose to join these international agreements and contribute to these organizations. But then the way that they enforce those rules is by withdrawing those very same benefits that they just created. And that's the main way, it's not exclusive way, but it's the main way in which international legal regimes operate, in particular international bodies operate. They create benefits and then they take them away. And when you think of it that way, you realize that when states choose not to join out of fear that an international body is going to interfere with their sovereignty, in effect they're making themselves voluntary outcasts because they're choosing not to accept the benefits of the organization in order to avoid imposition on their sovereignty. But in fact, the organization, the only power that the organization would have is to withdraw the very benefits that it itself has created. And so I think it turns this idea of sovereignty and the imposition on sovereignty to some degree on its head, and lets you realize that rather than imposing on states, rather than forcing states to act, in fact, it gives states certain kinds of benefits that are important to states' capacity to satisfy the interests and needs of their own citizens. And that the only way in which they really discipline in most cases, in the vast majority of cases, is by withdrawing those very same benefits. So with that, I'm going to stop and listen to my colleagues, and I very much welcome questions and thoughts about this and look forward to our conversation.
Thank you very much for inviting me to talk about international delegation sovereignty. I'm largely going to be talking about the question of how far such international delegations threatens democratic accountability. Before I do that, let me just say there's one other aspect of sovereignty I think that might be interesting to talk about, and that's the idea of sovereignty as a mechanism of jurisdictional competition in the world, that different nations do things differently, and that's not only be valuable to them, it may be valuable for learning things for the world. And I think that goes right back to the beginning of sovereignty in the Westphalian settlement. The alternative to sovereignty was to follow immanent rules from the Catholic Church at the time, and sovereignty in that sense I think is a concept that has an idea of independence, an idea, dare I say, almost of Protestantism, doing things differently built into it. But let me talk about what my real focus here, which is democratic accountability, and I totally agree, I want to begin on a note of agreement with Professor Hathaway, that sovereignty actually is enabled by being able to go into international agreements, just as an individual gains autonomy from being able to enter contracts. There's no doubt about that. And that when there are issues, we heard yesterday from Professor Krasner of collective action, we may well want to enter into agreements with other nations when we have market failures or externalities from one nation to another. So there's just no doubt that that is consistent with democratic sovereignty. And we also may want to delegate authority to make decisions about the nature of those agreements. For some of the same reasons, we may need an agreement. We may need some judge other than the nation itself of whether it's complying with an agreement, some impartial judge. So all of that seems to me exactly right. And so the question is, how in our constitutional system do we make that consistent with democratic accountability? Because we know even from our own domestic regime that delegations raise questions of democratic accountability. That in some sense is the story of administrative law, that accountability to agencies creates problems of democratic deficit. They create agency costs. It's hard to control the agents. They could create problems of agency capture, that special interests may be able, because agency action is less transparent to the general public, to do better. So the fact that we have a delegation doesn't get us around the problems of democratic accountability, even domestically. And one might think that externally, if we have a delegation externally, there are some additional problems, that that's actually even less transparent to the ordinary citizen. They don't know what's going on often in Washington, but certainly not in Geneva. that's too much to ask. So it really exacerbates the problem of the democratic deficit. You might also think it exacerbates some problems of agency costs as well. In our system, we have generally over the agents. The president reviews them. We have hearings of Congress where they can bring up someone who's been confirmed, put them in the Klieg lights, constrain them in that way, and yet that isn't true internationally. Now, I've given this as sort of a domestic perspective, but I think even if we broaden this to an international concern, one can say that generally, nations may have trouble controlling their agents, precisely because these agreements have multiple principles, and that allows the agents more slack. It's very hard for multiple principles to control their agents. So all these are really substantial problems. Now you might think, well, those are problems that Congress simply can address. It's very clear that Congress can address them by entering into a delegation, entering into an agreement to delegate power or not. But even we don't think that even completely domestically, because we understand that sometimes it's in the interest of political branches to deflect democratic accountability. They prefer not to be accountable. They prefer to delegate things, maybe even the hopes of agency capture, because then they'll have the benefit of the concentrated group and the citizens in general. It really won't be very transparent to them. So that's the problem one has in the context, I think, of international delegations. They may be very useful. On the other hand, they may have substantial costs. And how does our political system deal with them? And I think they can deal with them in two ways. One, ex post, and the other ex ante. I'll begin with the ex post way of addressing the problem. And that is suggesting that we'll just delegate something as a matter of international law, but when the delegatee makes a decision as a matter of international law to be bound domestically, some domestic actor, either Congress or the president under a delegation from Congress, must bring it over the transom, as it were. We actually have systems like that. Professor Martinez mentioned the WTO. The WTO's delegation, which I think is the most effective international organization, is a delegation in which the panels which adjudicate WTO disputes do so under international law. They cannot change our own law without a decision by Congress to change it. Nevertheless, and I think here Professor Hathaway's paper is again very valuable, that is still an effective system, because the structure of it is that it permits, again under international law, retaliation against the United States if the United States doesn't follow the decisions of the WTO. And that's actually going to have an effect, because the genius of the WTO is that it allows retaliation on concentrated groups, exporters who will not, because of greater tariffs overseas, be able to gain as much. They then will lobby Congress to bring us into compliance with the strictures of the WTO. An example of that came in 2004 when the Bush administration tried to put up tariffs on steel, which was found to be GATT illegal, or WTO found it illegal. And there was authorization of retaliation, and lo and behold, the retaliation took the form of higher tariffs in states, all the swing states that the president needed for re-election. So it was a very effective way of getting compliance, and nevertheless it preserves substantial democratic accountability. The president, Congress have to make these decisions in particular, and this becomes, in some sense, what I think political scientists might see as a kind of fire alarm. If there are these decisions that seem to be consistently bad, it's a point at which they're going to be reviewed in our domestic system to comply with these strictures of the WTO. So that, I think, is the simplest way, and as I say, I think the GATT is the most effective system of all international law and gaining compliance and gaining it for a very good cause that helps wealth among nations. Now, some people suggest we can expand the GATT. We should just do almost everything through the GATT and take advantage of that system. That may not work. Note that the exporters are getting something very useful from a free trade or a freer trade structure. If we have environmental regulations and try to enforce them through sanctions against exporters, they're going to be less eager to be within the GATT, within the WTO in general. So it's not clear that that system will work for all kinds of agreements we want to enter into with delegations. And so that brings me to the next example of how we deal with these problems ex ante, and that is through, I think, the treaty clause. And there's something positive I have to say about this, and then there's really the bitter with the sweet that you get with the treaty clause. In my view, and this is an area where I've changed my view since I was at the Justice Department. I took a different position in a memo, I guess, almost a quarter of a century ago. But my view is that the treaty clause does allow for international delegations that have direct effect in the United States. In other words, that come directly over the transom. And you might say, well, there's some structural problems with that. The appointments clause might be one of them. In general, people who operate under the laws of the United States have to be appointed. And that obviously isn't largely going to be true of international tribunals. Might have problems with Article 3. I nevertheless think that the nature of the treaty provisions suggests that that kind of confederal power can be given to international bodies. I'd begin with an analogy. I think we see a very similar problem in putting American troops under foreign command. Generally, one might think that, and we do require confirmation of our officers, and that would be a problem. But because we understand that the commander-in-chief power contemplates alliances, we would not think that a violation of the appointments clause to put troops under the command of a foreign general in an alliance. Similarly, I think the treaty clause was understood to be able to enter into confederal agreements, which might have direct effects. Here I would point to some sorts of evidence for that. I see David Golub is in the audience. He wrote a very interesting paper suggesting that you should look at the Articles of Confederation that had some direct effect. After all, that was a kind of confederal treaty that was known to the framers. I think also we see in the original debates over the Jay Treaty some other data for that evidence. Some of those mixed tribunals which were adjudicating were disputed. Indeed, there were arguments that they violated Article 3. And Alexander Hamilton said, no, the treaty clause is capacious and enters into all these different kinds of treaties, including alliances and confederation. And so that's the positive side. I think that the nature of the treaty clause suggests that, at least with respect to those structural points, not perhaps with respect to our Bill of Rights, we can get to that perhaps in the Q&A, that actually permits us to enter into direct effect here. Nevertheless, Alexander Hamilton also said, well, there's actually some protection here. The capacious power of the treaty, he said, was carefully guarded by the Senate and the President. And what happens is you have a higher threshold ex ante to enter into such delegations. It's much harder to get than ordinary legislation to get 2/3 of the Senate. And one can show that if one's concerned, if there are substantial costs, as I think there are of international delegations with direct effects, that one way of dealing with that is ex ante to force those costs to be paid by having a higher threshold for passage. We see that in other areas of our law, certainly constitutional law itself. You might say, as a bit of a democratic deficit, allowing judges to make these decisions, and yet we agree to do that because we go through a strong supermajoritarian structure for ratification. Similarly, with agency costs, this is a constraint ex ante on these difficulties. Moreover, one of the things you would expect, and one of the things I would hope to have happen as we move, and I think we will move to a world where maybe more international delegations are needed, the fact that these will be hard in the United States actually will put pressure to find international structures to constrain the international actors, because it will be difficult. We'll think of creating kinds of separation of powers internationally to constrain these delegations and the kinds of possible costs to democratic accountability. So my final answer is we actually have within the United States Constitution the resources to deal with a real problem. There's a real problem of democratic accountability in international delegations, but we have the resources to deal with it either ex post or ex ante as we choose. Thank you very much.
Okay, thank you. Okay, so I'd like to thank Professor McConnell and Stanford for putting this wonderful conference together. It's a pleasure to be here and a pleasure to be on the panel where I can begin by agreeing with the sentiments expressed both by Professor Hathaway and my colleague, Professor McGinnis. I'm also not inherently alarmed by international delegations and delegations to international organizations. The voluntariness of these delegations will generally ease concerns about sovereignty, if sovereignty is basically understood as nations acting as they would wish to. However, there are particular issues that could arise, and if one adopts a particular understanding of what the sovereignty problem is, then we can have particular issues with individual constitutional systems. So first I'll make some general observations about the nature of the question, and then I will speak a bit more about judicial delegations to international judicial authorities, which I think under the United States constitutional framework may be slightly more complicated, but also far from intractable. So many of the complaints that we hear, the kind of alarmist rhetoric that Professor Hathaway describes about delegations to international organizations and the loss of national self-control resulting from that, are really, I think, complaints about the inefficacy of domestic democratic politics in certain countries. So the complaint, for example, of Eurosceptics about an increasingly powerful Europe is really properly understood, I think, as a complaint about the national political elites of the respective countries not taking no to a series of referenda for an answer. But that was something that was done by the respective European nations, not by Europe. There could be some exceptions, and I think these exceptions are relatively rare but worth noting. So there could be pressure to join international federative institutions. This pressure could result for a variety of reasons. Sometimes some nations have federative preferences on a greater scope than others, but they need the minority to go along with them for economies of scale and so forth. So you can imagine this could be like pressure to join a union, like pressure to join any kind of buying club. Sometimes you want more people in with you, and you could coerce them through economic pressures and so forth to join. We have this kind of concern, or you could have tying arrangements. So a tying arrangement is when the benefit of the international institution offers its members is unrelated to the sovereignty-related requests that it makes. And the European Union does this a lot. So they say, you can join our essentially economic union if, for example, you get rid of, if you don't execute your Kurdish guerrilla leader, if you're Turkey, if you hand over your war crimes suspects, if you make reforms relating to your divorce law, if you're Turkey. Things which the European Union probably could not force itself during membership, but could have as a condition on membership. And generally, we don't like tying arrangements when you use your power in one market to get unrelated benefits in another market. I think that's a legitimate kind of concern. And we see that your membership of the European Union has lots of deals that come with getting into it. But I think those are generally the exceptions. One final thing to note, which I think we see today, the federative structure could be such that for practical purposes, disaggregation could be extremely bloody and effectively impossible. And we see this with Europe today. But you could also argue that we see this with the United States in the 1860s, that a degree of integration could be reached that withdrawal is effectively practically impossible, and that does create problems as we can see. Okay, now sovereignty, what I take as the sovereignty complaint for the United States would be a complaint that the powers delegated exceed powers that could be legitimately delegated under our constitutional system. Now, different nations could have different versions of this problem, and I believe many nations do have some version of this problem. For example, in the United States, we could participate in World War II and have US troops under a foreign commander, a British commander, for example. Many countries have constitutional provisions that prohibit their nationals from being under foreign command at all, that prohibit foreign troops from being in their countries at all, and thus effectively limit international defense cooperation and defense treaty organizations. The United States doesn't have those kind of restrictions, but it has other kinds of restrictions, and I think we shouldn't be surprised, given the diversity of constitutional arrangements, to find different countries will have different problems in this regard. And the nature of sovereignty from nation to nation varies. So in the United States, what sovereignty means might be a little different. For example, the federal government, I would say, has less sovereignty to give up than other countries, since it already shares it with the states. Now, a good place, I think, to start thinking about the general parameters of acceptable delegation to international organizations in the US Constitution would be the non-delegation doctrine. Because if the federal government could delegate the powers solemnly granted by the Constitution to a few bureaucrats in the Federal Bureaucratic Commission for Regulation, just to make up an organization, who no one's ever heard of, why not to some equally talented people maybe more talented people in Brussels? So what do we know about the acceptability of delegations? We live in an age of delegations. We shouldn't be worried about this. And generally, delegations are okay, but there are some limits. Most international delegations, I think, will satisfy this, but you still need to keep an eye on the limits and not confuse the acceptability of many delegations with a general rule of permissibility. For example, delegations need to have a limiting principle. They need to be with respect to something in particular and to foster a particular goal. They need to have some particular legislative policy judgment. The WTO, for example, clearly satisfies this. The goal is to, over time, lower trade restrictions. But if the WTO was like US antitrust regulators, was like the Sherman Antitrust Act, whose goal is to increase competition and at the same time decrease competition, as Judge Learned Hand said in the Alcoa opinion, could be more complicated. It's important that delegations be reviewable by the judiciary to make sure that the delegate is acting within the scope of delegation. So even if within the scope of the delegation, the delegate, the agent, has plenary power, the judicial review under the Federal Administrative Agency Acts requires the ability of some check, of some judicial check. In other words, the US would still need to get the last word on whether the agent is acting within the scope of delegation. And you can imagine many international mechanisms where it's actually the agent who gets the last word. So, for example, in the International Criminal Court, an example I know better than some other institutions, the ICC, for example, gets the final decision on whether a nation is unable or unwilling to prosecute crimes within its jurisdiction, which would trigger the jurisdiction of the ICC. The ICC gets the last word on its jurisdiction. Within domestic delegation doctrine, the delegate, the agent, never gets the last word on its jurisdiction. Finally, what I think is particularly crucial for the legitimacy of these delegations, both as a general democratic matter and a matter of delegation doctrine, is the ability for exit. And Professor Hathaway stressed this. You enter this voluntarily. You can leave at any time. I think that's right. And a couple things about the US constitutional system help this. And we probably want to protect those things. One, I think this helps shed some light on unilateral presidential withdrawal power. It's a little bit of a curiosity, right? Usually we get into legal arrangements and we have to get out the same way. We make a constitution, we need a constitutional amendment. We pass a law, we need to pass another law. But here we make a treaty with the Senate and then the president can just push a button and out we go, I think that greater ease of exit facilitates the legitimacy and constitutionality of these delegations. But probably the last-in-time rule also helps. So that's another method of exit, and we heard suggestions yesterday from Professor Hilserbach that maybe the founders were not so fond of the last-in-time rule, but I think it definitely helps with international delegations. Now, finally, you could imagine treaty arrangements that pose problematic limits. Let me give another example from the International Criminal Court, and I believe these kind of rules are going to become more common. Normally, treaties are denounceable upon notice. The International Criminal Court, and I think as we see a greater desire for true global federative integration, you will see more of this. To the extent that you can withdraw, the threat to sovereignty is lower, as Professor Hathaway pointed out, but so is the genuine nature of the federative commitment. So to have a stronger commitment, you need limitations on withdrawal. The ICC treaty, for example, has a 1-year limitation on withdrawal. Now imagine if you had this in a regulatory statute, a statute delegating agencies to an antitrust authority. The antitrust authority can make whatever rules and policies it wants, and Congress, if it doesn't like them, can override them after a year. I think that would be an obvious problem as a matter of domestic delegation. The whole notion of delegation is it's just a delegate, just an agent, and Congress can override that at any time. So I think a 1-year limitation on override, a 1 year is, I think, a non-trivial period, would be potentially problematic. Now, Professor Rosenkranz might suggest, I don't know if he actually would suggest, but he might suggest that actually there would be no constitutional problem signing such treaties, because the only constitutional violation would arise when Congress would actually want to, or the president would want to, denounce the treaty, and then the treaty would say no, but then that just means we would get to ignore the treaty. But I think it's probably not wise policy, as Professor Hilserbach suggested yesterday, to enter into treaties we know there are significant terms that we would find unconstitutional or otherwise could not abide by. Let's turn briefly now to the question of judicial delegations. Professor Martinez and I have both written on different sides of the question of the slave court tribunals, and I'll get to that in a second. But since we've already written about that, I want to talk about something new, the International Prize Court. So in 1907, there was a Hague Convention, Second Hague Convention, which resulted in the Hague Convention rules that people may be familiar with. And one of the products, the more successful results of this conference, several people, I believe Eliyahu Root wrote in the American Journal of International Law, if the Hague Convention did nothing else, it brought us the International Prize Court. And this would be a court to hear cases of prize on appeal from the top prize tribunal of each nation, because prize court is supposed to sit as an international court and apply international law, but there was a perception, surprise, surprise, that national prize courts applied prize law in a way favorable to their captures. So this was a concern, that national courts were biased in this process, and the International Prize Court would protect neutral interests by being unbiased. This was not just some kind of small idea. This was seen specifically by Roosevelt, by Taft, who mentioned it in several prominent speeches and State of the Union speeches, as the germ of a broader system of international justice and the beginning of greater global federative integration. The guy who wrote the treaty won a Nobel Prize for this and a few other things in 1910, and pretty much every issue of the American Journal of International Law from 1907 through 1912 had an article about how great this was and how you shouldn't be afraid of it. So it was pretty much a big deal. American diplomats were pretty enthusiastic about it. As soon as it got to the Senate, we heard that there was a problem. Who's the top prize court in the United States? The Supreme Court. Well, if this court can hear an appeal from the Supreme Court, then it's not the Supreme Court. That's a problem. You can't have a court that has review or can issue binding instructions to the Supreme Court, the thought was, without undermining supremacy. And then there was a more kind of general non-delegation, Article 3 delegation concern, that if this court could bind the Supreme Court, if it could reverse it, bind it as a genuinely hierarchical superior court, then it would seem to be outside of the Article 3 structure. Now, I don't have time to talk much about the slave courts, but I'll say something that applies both to the slave court story and to the prize courts. In neither of these cases, did diplomats throw up their hands and say, well, we're just totally stuck. Right? In both cases, various workarounds, maybe thin workarounds, were found to accommodate constitutional concerns and the desire to join these organizations. So, for example, in the case of the prize court, in the case of the slave trade courts, they announced that they understood the treaty as being limited to matters for which one wouldn't need a jury or that otherwise would not implicate individual constitutional rights. And in the case of the prize court, they created an additional protocol, a separate protocol, just for the United States, where in the case of the United States, instead of being a direct appeal, it would be a collateral proceeding in which it would basically be a request of indemnification directly from the United States, and thus more like the Jay Commission proceedings, where it was a public right and the money would come from the United States rather than private parties and the Supreme Court. So it would be a collateral proceeding of a state-to-state nature, just for the United States. Nobody seemed to mind that America had, and in the end, the thing never actually got anywhere because of, it turns out that no one knew what this objective prize law was that courts should be applying, and then World War I started. But in any case, accommodation is possible. So the fact of constitutional difficulty should not be surprising. Several nations have had to amend their constitutions to join the ICC. And I think one needs to treat them seriously. One needs to think that maybe they can be dealt with. One shouldn't say, constitutional objections, and one shouldn't say, international delegations. Right? So these can be accommodated, and one needs to be sensitive to it. The ICC, I think, happens to be a particularly tough accommodation because of its no reservations clause. So again, to the extent that we increasingly see stronger commitments like no reservations clauses, the International Prize Court did not have a no reservations clause, and they created this whole separate proceeding, essentially, for the United States. That makes it more, and the slave trade courts were bilateral, so reservations were not an issue. So there's different degrees of international delegation. To the extent one wants really strong ones, no withdrawal, no reservations, the strength of those commitments actually makes them more problematic, but the kind of commitments we usually see, easy withdrawal.
Assured by many of the actual structural features of international institutions that exist as a means of sort of limiting some of your concerns. So Oona talked about the prevalence of what she and Scott Shapiro call outcasting as a means of enforcement, that is the withdrawal of benefits as being a type of enforcement mechanism that alleviates some of the concerns we might otherwise have about infringements on sovereignty because it's the withdrawal of a benefit that comes along with membership. Professor McGinnis talked about the ex post and ex ante factors in our political system, in our constitutional system, both in the way that we implement international decisions ex post, the way we enter into international agreements ex ante, and Eugene talked about sort of the problem of delegation, and in particular delegation to international courts, but also the mechanisms that have been found at various times for working around that. I'm going to name 4 international institutions or bodies, some of which the U.S. is a part of, some of which are European. I want to see if I can get you each to rank them in terms of which is the most frightening to you in terms of sovereignty and why, or are they, or do none of them pose concerns? So the 4 that I'm going to name are the GATT and the WTO, the International Criminal Court, the European Court of Human Rights, and something that isn't exactly a sort of a body or court, but the euro, a common currency that's shared among different countries, the decision to combine monetary policy. Are there any of these that concern you more than others? If so, what structural features of that one concerns you the most? Do any of them pose any challenges to the theories you've already put forward?
Well, you pose a hard question, though. I guess I think that thinking about it as a sovereignty concern is kind of the wrong question to ask. I think the question is, when states are facing each of these, the decision whether to join the GATT, the ICC, the European Court, and the Euro, the question is, what is it they're going to get out of it? And are the costs of being members in these organizations greater than the benefits? And so states are looking at each of these. So, for instance, the GATT, and seeing that joining the GATT and being a part of the WTO does mean having to abide by all the rules and regulations that come with that. It means giving access to lower trade barriers to other countries, allowing more goods into their own countries, being willing to abide by or at least accept the legality of the dispute resolution by the dispute resolution bodies. But in return, they receive access to lower trade barriers abroad, access to those same dispute resolution bodies when they feel that they've been wronged, and they have to make the decision as to whether those benefits exceed the costs. And most countries have decided yes, and they do. In fact, they desperately want to be a part of the organization. When it comes to the ICC, countries may view that calculus differently. And so I guess, and same thing with the European Court of Human Rights and the Euro. So I guess I would say my own sense of it is that what I'm trying to do is flip the question on its head and not just look at what are the costs. We have to recognize that there's the benefits, and that states are in the position of making that decision for themselves. And when you recognize that there's consent and that there's significant benefits that are drawing states into these organizations, that then you see that it's a mistake to focus entirely on the cost side, which is, I think, what people are thinking about when they're thinking about sovereignty costs of being a member of these organizations. And that's true in nearly every instance that has this character. So I guess that would be my response, although maybe not perfectly responsive to your question.
I'll just talk a bit about, as I've already talked about, the GATT, which I'm extremely enthusiastic about and don't worry about at all, but I'll just focus my bit on the Euro and more generally the European project, because I do think that plays into one of the themes of my remarks. I think the Euro is, let me say, I'd be very worried if we were joining the Euro tomorrow. Very worried indeed. And I am worried about the European project for some of the reasons I've sort of suggested, because I think they've failed to have a sufficient threshold. In some sense, it is a constitution-making structure, and yet I think they haven't had the stringent, kind of qualified rules that I think also tried very much to force people to vote again if they voted against the Euro, and so are going into further integration into Europe. And I think that is somewhat problematic, because I do think the European project creates a lot of power in Brussels. That may be a good idea. I think there's some indication it hasn't worked out perfectly. And I think one of the reasons it hasn't worked out perfectly is there wasn't a sufficient structure of real constitutive deliberation. And one of the things that gets us to constitutive deliberation, I think, are more stringent voting rules. So, for instance, if the countries of the Euro had all had to agree by substantial qualified majorities, I think there would have been a lot. They may have agreed on something different, and not, I think, the somewhat rickety structure that I think is getting not only Europe into a lot of trouble at the moment, but the world into a lot of trouble. So I do think I have some concern about the European project, that it doesn't have a sufficiently transparent, deliberative structure that requires a very strong ex-ante buy-in by a substantial consensus of the people who are entering it.
I think, I'm also not about the GATT and WTO. I think the Euro and the European Court of Human Rights would be of greater concern. The Euro, for reasons previously alluded to, it's the kind of thing that once you're in, it's not simple at all to leave, and so that is effectively a constitutional commitment. That effectively is a constitutional commitment. It's a commitment which, when made by the people who originally decide, essentially binds the nation in perpetuity, and then one would want those commitments to be made with the supermajorities or extraordinary deliberation associated with constitutional commitments. The European Court of Human Rights, I have concerns about because of my perception, and I haven't followed the matter too closely, that it is a court which has sought rather actively after a while to expand its purview, and yet opting out can be difficult both because of pressure from other members who want to see a greater field of membership, pressure in various ways. And again, to pick up on a point Oona mentioned, that concerns about sovereignty are hard to understand because the real issue is you get benefits and then the benefits can be taken away. I think many concerns about sovereignty can be translated. The way to make sense of them is when we say we have this sovereignty concern. The way to translate them to understand Professor Hathaway's concern is to really say that those benefits, what you call benefits, are really not so big. So our sovereignty concern is we don't value those benefits, because there's also inflamed rhetoric on the other side, which seems to suggest one version of an inflamed rhetoric is that delegations to international organizations are inherently problematic and compromise sovereignty. The other version is that delegations to international organizations are inherently great, because having countries join international delegations is just a wonderful thing. And so that version just rates the benefits much more highly. So it depends what one thinks is are the benefits, and the benefits, and attaching a value to the benefits of the European Court, for example, could be very difficult.
All right, let me throw out another question, and then I'll open it to the audience. I want to press everyone a bit on what exactly your theory of sovereignty is. All the ideas you proposed work very well for the United States because of our Constitution. We have a democratic system that functions with occasionally some problems, but more or less well in a democratic way. Of course, there are many countries in the world that are not democratic. And so to the extent that almost all of your arguments for why we should be concerned about delegations to international institutions turn on the alternative being a kind of democratic accountability and legitimacy at the national level. Does that mean we shouldn't be concerned about infringing on the sovereignty of non-democratic countries? Let's say, Gaddafi's Libya or other countries that are non-democratic.
So it's an interesting question. I think it brings us back to this point that the decision to join these organizations is made by the domestic political legal order. And so John, I think, pointed to this in his concerns about the euro and about the European institutions, is that the concerns for him bottom out in concerns about the way in which these states are providing for the decision to join into these organizations, and questions about democratic deficits in that domestic political process. And so I think maybe, Jenny, one of the things you're pointing to is this question about whether in these states where there's no domestic political legal order that is in a sense legitimate, and therefore the decision to consent to these international organizations cannot be understood really as having kind of democratic legitimacy. I mean, the problem is, again, like, what are we focused on here? Because it's not so much the problem of the international body so much as it is the domestic political and legal order. And in fact, I actually have complaints about that when it comes to the United States. And I actually think that the treaty clause is problematic in a variety of ways. And I'm sure I could come up with similar kinds of arguments about Gaddafi's Libya. So I've written extensively about why I actually think that the treaty clause is less democratic, has democratic deficits as compared to, say, ex-post congressional executive agreements, which provide for both houses of Congress plus the president making a decision to adhere to an international agreement, as opposed to 2/3 of the Senate plus the president. I actually think that that the treaty clause is problematic in two respects. Just very briefly, one, I think it's over-inclusive in that, or overprotective in that the 2/3 rule leads to huge numbers of treaties that would be beneficial to the country not getting ratified, because that barrier is an extraordinarily difficult barrier to get over. 67 senators, hard to get them to agree on anything. And it's almost impossible to get them to agree on international agreements that actually do anything of substance. And so you see this multi-decade debate going on about the Law of the Sea Convention, for instance, that we're still kind of talking about the Law of the Sea Convention, even after it's been rewritten to address U.S. concerns. And on the other hand, you're excluding the House of Representatives entirely from the process, which was done originally for certain kinds of particular reasons, which I'm happy to get into, but no longer seems to me particularly relevant today. So the fact that I say that I think that we're asking the wrong question when we're saying, do international bodies threaten sovereignty? I'd say, well, you have to turn that on its head. International bodies give sovereignty, and they give certain benefits, and you have to see that side of the equation as well. But I do actually think that it's legitimate to ask questions about the domestic, legal, political process for adhering to those agreements, and to ask whether those are sufficiently democratically legitimate, and whether those can or can't be improved. And I, in fact, think that our own system could be improved substantially for making those commitments.
Well, let me say, here is a bit of disagreement, I think, on the panel, because I don't find the treaty clause offensive on democratic grounds, but that's because I'm not a majoritarian. I don't think that democracy is quite equivalent to majority rule. If you look at books like theories like public choice theories, like the calculus of consent, there are dangers to majority rule. Sometimes in certain areas you get very high external costs there. I pointed to international delegations as an area where you actually might think will be better off because of the costs of delegation with a different kind of voting rule. And so that is a debate about voting rules. I don't want to detour from, I think, the very interesting question, which is, what about other countries? I think that what I begin with is I'm suggesting that certainly the United States remains a democratic country, even if we have bicameralism and presentment treaty clauses, which are in some sense a departure from bare majority rule. So my view of a democratic country is a country that does, through a variety of voting rules, seek the consensus of its people. And there could be a variety of voting rules that might be appropriate given its traditions and its evaluation of the trade-off between external costs that majorities may impose and the information costs that a higher rule. So that's my view of what a democracy is. So there are a lot of democratic countries in the world. But since I'm a welfarist, if a country is completely non-democratic, if it does not reflect the welfare of its people, I really have no problems. There may be prudential reasons not to invade them, not to attack them, but I don't find any other good reasons. I don't find any reasons in sovereignty itself, because I see the object as sovereignty as a proxy for welfare of individuals in the world. And there may well be, and this could have, I think, implications. For instance, I'm very concerned about using customary international law to override or to constrain our president. I think there may well be an asymmetry here. I don't mind the use of international law to constrain totalitarian or authoritarian nations. I think it's not necessarily a two-way street, and that comes from my view that sovereignty, we have to be very cautious about sovereignty. We have to be cautious about it because we have to understand that it may well, at least if it's structured correctly, be a proxy for individual welfare. I'm not at all confident that it's a proxy generally. Let me just finally make one caveat. I'm very strong about prudential matters. It may obviously be a very imprudent thing to go into other nations, but that, I think, is a matter of prudential calculus rather than that I think I would be restrained by some abstract concept of sovereignty.
Okay. So we have international delegations by non-democratic states. I think that's what the question is about. So you have, for example, countries like Libya that join international organizations. And in Libya, they did not ask people what they thought about matters of public policy. You have regimes like Europe joining international organizations. In Europe, they asked people, and if they didn't like the answer, they asked again. So you have a variety of non-democratic entities participating in international regimes. One angle of this question we haven't explored is, so Libya joins the, Libya was the head of the African Union a few years ago, the head of the Human Rights Commission recently. So to the extent that we participate in international organizations in which are also participating non-democratic regimes, the democratic average of the decision-making is obviously being reduced. I think this is a point that John is also concerned with. On the other hand, if our concern from a domestic perspective about international delegation is a reduction in the democratic nature of decision-making, if a non-democratic state delegates to international organizations in which there are democratic nations, from their perspective, it could be an increase in the average of the democratic decision-making. But again, we should understand that the organizations in which we participate in include non-democratic nations. I think that's a non-trivial concern. Should we care about the system of sovereignty in general? Should we care about the sovereignty of other nations? I don't think there's any significant constitutional value in it. I think sovereignty, I've always thought of sovereignty as very much akin to common law rules of property and preferences for clear title and simple fee estates. That is to say, sovereignty is useful because it tells you who's going to be responsible for a given set of problems arising from within a territory. And the problems we see now in Iraq and Libya is that if you decide to break down that sovereignty, at least until it is replaced, it becomes entirely unclear who is accountable and who can be held responsible for problems resulting from a particular place. So from a purely instrumental perspective, it seems it's good to have someone in charge, and the basically parcelization of the globe and the creation of clear property rights in states helps promote the internalization of costs. But from a constitutional perspective, it doesn't seem to matter much.
All right, with that, I'll turn it open to the audience. If you could come to the microphone and please give your name.
Steve Krasner. So first I wanted to make a point about sovereignty. For international lawyers or lawyers, you guys seem to me incredibly confused in the sense that you view sovereignty in at least 3 different ways. So one, you've talked about sovereignty as international legal sovereignty, which is international recognition. That's Oona's point, that countries enter into treaties voluntarily, therefore there can never be a violation of sovereignty. All right, secondly, you've talked about it as Westphalian sovereignty. I have to say, Professor McGinnis, your interpretation of the Peace of Westphalia is completely incorrect, although I know it's a common definition, but we can talk about that later if you want. But where sovereignty means domestic autonomy, that there's no external authority structure. And third, you've talked about sovereignty in terms of domestic governance. That was Professor Kontorovich's last point about what's happening in Iraq now. These are distinctly different things. It seems to me for the issues that you're talking about on this panel, the fundamental problem is that states use their international legal sovereignty to contract away their domestic sovereignty. That is, they change their domestic authority structures, clearly in the European, if you look at the European situation with the European courts, and they can contract away their Westphalian sovereignty. That's the nature of the problem, which I think you've talked about in this panel and was talked about in the panels yesterday. All right, and then I have 2 questions. One's a question for Oona, which is really, this is naive, but you talked about outcasting, which kind of sounds like banishment. But aren't the things that you're talking about really, and God, it makes me shudder to say this because it's like a lawyer's question. Isn't this more like contract law? That you enter into a contract, you violate the contract, that's what the WTO panels do, and therefore you don't have to pay, so you get to withdraw the concessions which you've given. So I'd be interested in, why use outcast instead of contracting? Obviously you guys thought about that. And Professor McGinnis, you alluded very briefly to an idea of a separation of powers at the international level as a way of checking international organizations, if I understood you correctly. Maybe it was sort of cryptic, so I'm not sure I'm getting this right, but if that's what you were talking about, could you say a little more about that?
So thank you so much. It's great to have you here, Steve. And it's always a little daunting to talk about sovereignty with Steve in the room, since he is the expert on the topic. So I think on your point that there are sort of several different definitions of sovereignty floating around, I think you're right about that, actually. And I think that's one of the things that is generally problematic about trying to talk about sovereignty is that it's kind of hard to know what exactly it is you're talking about. I guess what I would say is that there are more connections, though, than maybe your question suggests, and that's part of what I'm trying to draw on. So the concept of international legal sovereignty obviously is fundamentally about the capacity to contract on behalf of the state. But what gives you, what is it that gives rise to those decisions? Well, it's the same domestic political and legal actors that make decisions about domestic governance. And so to the extent that it's those same actors that are making the decision about when and how to contract, when and how to enter into these international organizations, and then they're making the decision that has implications for domestic governance. You can't think of them as entirely divided or separated, like one part is selling out the other. It's the same entity that's making the decision to enter into these agreements that then constrains its capacities in these other arenas. In Westphalian sovereignty and domestic governance, as you pointed out. So that's what I think I'm trying to highlight. On your question as to outcasting sounds a lot like banishment. You're right. In fact, this very long article that we've written has a section on Icelandic outlawry. And talks about banishment as an outlawry was kind of form of banishment. You were sort of sent out as a way of enforcing the law. And we actually used that as our starting point for building up this idea of outcasting to show that actually in Iceland they didn't have police. The way in which they enforced it, their domestic law was precisely through exclusion, through denying you the benefits of membership in the community. If you were, say, found to have murdered someone, the result was not that you were thrown in jail, it was that you were cast out of the community and no longer allowed to enjoy the benefits of being a member of that community. And we draw from that, then we build up to international law and the concept of outcasting, both in domestic, and actually the subtitle is enforcement in domestic and international law. So we're actually trying to build a broader theory of enforcement. Your thought that this sounds a lot like contract law, I actually would say that we have grand ambitions for this theory that draws within a contract law as well. And so we're trying to think more generally about developing a theory of thinking about enforcement that would incorporate both aspects. So you are of a similar mindset to us as well, and I'd love to talk to you more about this.
To the question of separation of powers at an international level, again, I'm thinking in some sense of what you might build in a place like the WTO. The WTO has, of course, what's best known about it is a judicial structure, the panel structure. It actually has some rules, which I won't go into here, for governments to come together and fill in interstices in the treaties, even in between rounds, to perhaps even constrain panels. You might actually think it doesn't even have in embryo almost an executive in the sense of the director. You might think of playing around with concepts like that and thinking of how that kind of separation of powers will do better at constraining the international agents. So that's my idea. I think the place I see it most clearly is the WTO. At the moment, it's been largely ineffective. The legislative powers of the WTO are not used very often. But my argument is that the very constraints, particularly in getting the United States involved in international delegations and our demands to be concerned about the agency costs that may come, may force international organizations, I think, to think a little more creatively than they have in using concepts that aren't not unlike our separation of powers to address real agency problems. It's not a condemnation of international organizations. Any organization has agency problems. And that's what I'm hoping we see, a more robust discussion of internally within international agencies to think of how to split their structures to produce better results and to produce results that reduce agency costs.
Go to the next question. David?
Hi, David Sloss. So both Professor Kontorovich and Professor McGinnis talked about international delegations, and I want to raise a question. It's mostly for Eugene, but others can comment as well. So you are suggesting, I think, that we ought to recognize constitutional limits on the power to sort of delegate authority to international bodies. And Michael, if what you mean by that is judicially enforceable constitutional limits, I think there are real problems with that idea. In other words, if what you mean is constitutional limits that are basically enforced through the political process, well, it seems to me that's happening, it's working. I mean, the fact is the U.S. is very reluctant to enter into a whole variety of different international delegations. So we have a sort of a self-enforcing limit, if you will, through the political process that limits those international delegations. But suppose the political branches decide, for whatever reason, to enter into some international delegation that you and a whole lot of other people think is a dumb idea. Does the judiciary really have the power to step in and say, no, you can't do that, it's unconstitutional? And recognizing that power in the judiciary, doesn't that create more problems than it solves if you sort of give the judiciary the power to step in and overrule the political branches on what is basically a political decision there? So, question for you.
Okay, so I think it's useful to note that to take the context of international courts, in the three instances that we can think of where the U.S. has dabbled or considered membership in international courts with direct jurisdiction over individuals for violations of international law, in the case of the slave trade courts, in the case of the international prize courts, and in the case of the International Criminal Court, the United States either did not join on the originally contemplated terms, and none of these cases have resulted in actual judicial controversy. So I think this is because of constitutional concerns. Even in the case of the ICC, which was extremely popular amongst diplomats and international professors, it's noteworthy that President Clinton did not submit it to the Senate for ratification, for while I'm sure he did not share the constitutional reservations voiced by some senators, he must have known that they were real and potentially politically popular. And it's also interesting to note that President Obama, it's most famous that President Bush unsigned, or whatever he thought he was doing, the ICC treaty, but it's notable that big fans of the ICC, President Clinton didn't send it to the Senate, and President Obama isn't even signing it. Now, I'm sure he does not share constitutional reservations that are out there, but he must be aware of them. So these things don't necessarily get far enough for these questions to arise, and that the history clearly supports the notion that this will largely be within the political branches. I think the political branches are important interpreters of the Constitution. I think they need to think about the Constitution. I think in the area of foreign relations, it's far from novel that they will have de facto the last word in constitutional interpretation. This was the presumption of the correspondence between Thomas Jefferson and the justices regarding neutrality, that certain questions will not be presented in a judicially recognizable way. On the other hand, that suggests that we maybe should be a little bit more sympathetic to the kind of hysteria that Professor Hathaway was describing, because that may be just the popular way of talking about these constitutional concerns, and if it will never wind up in court and needs to be just a popular judgment on the extent to which the political branches are observing their constitutional limitations, then that's a very valuable public discourse. Finally, it depends, to get to the specifics of your question of judicial involvement, it depends really on the nature of the treaty. If it's a pure country-to-country commitment, that would more easily be thought of as a political question. So I think some treaties will be political questions, but it's hard to imagine all treaties will be political questions. It would be very hard for me to imagine that if a treaty provides that an American will be handed over to the U.S., Iraq, Afghanistan Terror Tribunal, in which terrorists will be suspected terrorists of any nation, will be prosecuted by a mixed commission consisting of a judge from each country without benefit of jury or appeal, that a habeas claim would not lie for an attempt to send someone for trial before such a tribunal. I find that would be hard to imagine. So it depends, I think, on the, and, you know, for example, Dames v. Moore versus Regan. You know, I don't think that the existence of an agreement precludes jurisdiction, but it depends on the nature of the commitment. And I think those touching upon individual rights, which I think the next generation of international courts are eager to do, are more likely to directly implicate the jurisdiction of courts.
My way to stand, I don't think I agree that, I mean, first of all, I want to be clear that I in general think the structural issues are dealt with by the treaty clause. So if something is done to the treaty, we may have rights issues. After all, the Bill of Rights is passed after the treaty clause. There may be a limitation on it formally. So that is, if it's done through the treaty clause, I don't really see a problem with claims about structural provisions. On the other hand, if the argument is we're entering into this without going through the treaty clause, I think that's totally within the Supreme Court's purview to decide. Indeed, I think that's a little easier in one sense than the kind of issues of rights the court decides generally. Because if the court says we can't enter into something because of a right, it's really very hard. It's very rigid. How will we ever enter into such a treaty then? This is just saying you've got to get a higher qualified majority rule. And so I think there's actually a sort of political science argument that the court should absolutely enforce the requirement that international agreements that give international delegations to international actors are quintessentially what the treaty clauses required, unless we accept the complete interchangeability thesis between between congressional executive agreements, which I just think is wrong as an original matter, the original meaning of the Constitution.
Let me add just one comment. I think if one is frustrated by potential obstacles that Article 3 or other things could pose to joining to membership in international organizations, I think the concern would be misplaced. Consider Britain, which recently had to fundamentally revise its constitutional system with regards to the role of the House of Lords in judicial review to satisfy European court issues. So countries not infrequently revise their constitutional structures because the constitutional structures don't fit particular international structures. International structures are written often without mind of particular constitutional structures, and there's going to be tension, and something is going to have to adjust, either the international structure or the national structure. I think concerns about the tension between U.S. Constitution and international organizations, the provision that people really are actually concerned about, though they might not realize it, is the amendments clause. In our case, it just happens to be very hard to make amendments. But that is the proper locus of concern, rather than judicial review or rights. And if one wants to change our Constitution to make it more amenable to international cooperation, one needs to, in Britain it was very easy. They had, 1,000 years of House of Lords being supreme in judicial review, but there's parliamentary supremacy, and they can change that on a dime. We need to make it easier to change the Constitution, given that we'll be confronted with a variety of heterogeneous international institutions.
All right, next question.
Yes, Trey Childers, Pepperdine Law School. It seems to me that so much of what is troubling the panel is either a delegation of the executive power of the United States or the legislative power of the United States to an international body. I wonder if the panel could talk a little bit about the potential delegation of the judicial power of the United States, either in terms of treaty interpretation, which of course raises the issue the Supreme Court tried to resolve in Medellin v. Dredka, Medellin v. Texas, or in the case of the WTO, the applicability of the appellate body of the WTO's valid and binding legal decisions in the United States. And I also wonder if taking up something that Professor Rosenkranz was encouraging yesterday in looking at the text, if the text of the Constitution tells us anything, in terms of the legislative power, it says the powers herein granted are to be exercised by Congress. In the context of the executive power, it says the executive powers shall be vested. But in Article 3, it says the judicial power of the United States. So I wonder if there's something either in text or tradition that tells us something about the potential for the delegation of the judicial power. And I also wonder, as an historical matter, I'm not an historian, but my sense would be that when the treaty clause and the treaty power was being thought about and written, it was not with an understanding that the judicial power in any way could be exercised by another body, because there weren't international organizations, I don't think, although I may be wrong, who had the ability to adjudicate treaty terms other than parties to the treaty, which in the context of interpretation of treaty provisions would be a standard common law process of looking to other signatories and the decisions of the other signatory states and determining what the treaty provision actually required. So I wonder if the panel could just talk a little bit about potential delegations of the judicial power, not just the executive or the legislative power.
Start with a crack about this. I think I did touch on the judicial judge. The prize courts is an example of concerns with judicial delegations, because judicial delegations of the Supreme Court were one of the things that proved problematic there. For things like the WTO and GATT that involve arbitration between states on a state-to-state level, even if there are individual actors that can bring petitions, the historical pedigree is pretty tight, dating back classically to the Jay Treaty, which created this hearing board to liquidate claims by creditors of the respective nations. Now again, that was not private party to private party. That was what we would call public rights from an Article III perspective, because it was claims that were satisfied by the opposing sovereign. So if a British creditor was owed money by an American, they would bring this claim to the board, and even though it was a private American citizen who would owe the money would be paid by the United States. And that takes it substantially out of the classic public rights model where the court has historically held Article III is needed. Now, it gets more tricky when you deal with suits that involve individuals in a more direct way, because then all of the, like the example I gave before with the U.S., Iraq, Afghanistan Terror Tribunal, generally we think that you can delegate away parts of Article III, maybe in the area of public rights, you can delegate broadly, but things like jury trial rights and whatnot would remain, and that will be a problem with courts that would fill a function where we would domestically think you need a jury, because juries are not used around the world, and why would an international court have a jury? It's a slow, weird, and idiosyncratic, cumbersome. It's an American idiosyncrasy. You need to first distinguish very much between two kinds of courts. Ones that would be more arbitral state-to-state tribunals, which I think are entirely unproblematic and have quite a good pedigree, and those that deal with, let's say, a more classic criminal adjudication, which raise more troubling issues, but
I actually agree with pretty much all of that. I would note one thing that's striking, I think that you're picking up on, Trey, is that when people talk about sovereignty, often a lot of the energy focuses on exactly what you're talking about delegation of judicial power. So the thing that seems to be, I mean, there are many things that draw people's fire when it comes to Law of the Sea Convention, but one of the key ones is the tribunal, and the sense that there is this Law of the Sea tribunal that could make decisions that then would be binding on American citizens, and kind of a sense of that is somehow different. And I think that Eugene's answer is a pretty persuasive one. And I also agree actually with his sense that there's certain limits on the capacity to delegate to the extent that it interferes with basic rights. Then I think there are both political checks on that, but I think there are also some independent substantive checks as well. But I do want to note just something that strikes me as a kind of interesting idiosyncrasy, which is that we tend to be very upset or concerned about certain kinds of delegations of judicial power and tend to not notice others that actually strike me as much more real. So we are very worried about the Law of the Sea Tribunal, which has heard something like 14 cases, 18 cases maybe now, I mean, a really small number of cases. But you almost never hear anybody raise concerns about the New York Convention on Arbitration, which in fact is leading to direct enforcement of private arbitral decisions in U.S. courts, where those U.S. courts can't, under the convention, inspect the legal basis for the decision. That seems to be much more worrisome than the Law of the Sea Tribunal, which hears almost no cases. and in fact deals with sometimes issues of real serious public policy concern. And yet we never hear sovereignty fears raised about that, which has always struck me as quite puzzling as to why that's the case. We also don't see the same argument made around the WTO dispute settlement body, despite the fact that, in fact, many of the decisions that are made by the dispute settlement body have real impact on Americans' daily lives. And so I note that as just a striking idiosyncrasy. I actually don't think that these are, I actually think that they're perfectly legitimate, but to the extent that people are worried about delegation of authority to international bodies, I think their ire is directed in exactly the wrong place. But in terms of who makes the decision about that, I think it's a decision that, again, ought to happen at the point at which you're consenting to these organizations, and then an ongoing conversation as to whether you want to continue to be a part of them. And I think in both the WTO and the International Convention context, we've decided, yes, these are valuable, these are worth it, the benefits we get are worth whatever costs that might be imposed. But that's a kind of democratic decision that needs to be made about when and how those delegations ought to be made and when they're beneficial and when they're not.
All right, next question.
Hi, I'm Colin Glassy. I'm a law student at Santa Clara. When I look at international organizations, the thing that concerns me is how they are controlled and by who. And when you have an organization in which essentially a very small country has an equal vote to a very, very powerful country, such as Malta has the same vote in certain circumstances as Germany within the EU, that strikes me as a real problem for managing any sensible question of sovereignty. I mean, we managed this in our own fashion with the creation of both the House and the Senate, and as our way of distributing power between the various differently sized, differently populated states. I don't see how the international organizations have dealt with this same issue, and I think it's absolutely critical.
Take that on.
So, if Germany didn't want to be in the European Union because its vote would be diluted by Malta, it didn't have to join. But of course, the countries that are most enthusiastic about the European project are Britain and, to a lesser extent, and much more Germany and France. So obviously, it's working out for them. Now, I thought you were going to give a different example with the euro and Finland, and you could say, how could little Finland be holding up the saving of Europe? Well, because little Finland is actually not so little economically, and so you need to look at the relevant axis of measurement.
One point I would add to that is even these international organizations, the differences of power do not disappear, right? They are still very strong within the WTO. It matters a lot if you're suing the United States. And the one concern is that smaller countries can retaliate against the United States. It's not going to make any difference, and that, I think, is the most serious question about the WTO dispute resolution process. So I think it's, the only thing I would caution, I think it's a mistake to think that, particularly in international organizations, that the juridical equality means anything like equal leverage in the outcomes. And I think it goes back to Eugene's. Germany has, even juridically, it has more votes in the various structures of it. But even beyond that, what it says matters in a way that Malta does not. And so I think that tempers that kind of equality concern, even if it doesn't dissipate it.
Let me add one note about global institutions and state size. There is an idea that political scientists have talked about that we often think of global institutions, international organizations, as promoting increased confederation and global unity, but there is evidence that suggests things like the European Union actually promote the opposite, that is to say, dissolution, because we see now, even in Europe and elsewhere, increased secessionist movements, local autonomy, etc., because in a context of international organizations, being small actually does have some value. So there's an idea that the European Union actually encourages Scottish independence and Flemish independence and so forth, because if you're just, as long as you're a state, that comes with a certain fixed package that actually increases the value of smallness. So actually the global federalism may actually have a centrifugal effect also.
One thing I would add, and very much along the same lines, is that the free trade structure of Europe also encourages that. It was one of the strong reasons to be part of a nation state is to get rid of tariffs. If you get that from an international body, there's less reason to be a part of the nation state. So, because you might have other things you don't like being part of England, Britain. Scotland's an excellent example because you have your own identity. That might be too high. Your identity might be too high a price to pay if you can't send your haggis around the world. But now you can still do that, even whether or not you're part of Britain.
Nick?
I just wanted to follow up on this question of delegation of judicial power for Eugene. So I understood the distinction you were making between adjudicating public rights and adjudicating private rights, and that makes some sense to me. Maybe we're not worried as much if these tribunals are adjudicating public rights, but I wasn't sure about the distinction you were drawing between the Article 3 concern and the Bill of Rights concern. So on your hypothetical, where we're trying somebody in one of these tribunals abroad, like a criminal trial, you said we'd be nervous if there wasn't a jury or if other Bill of Rights protections weren't being complied with. But imagine that they were. I mean, imagine we were flying a jury over and giving you a lawyer and complying with the Bill of Rights across all those particulars. Would there not be an independent Article 3 problem? Aren't you entitled to an Article 3 judge in that context, quite independent of the Bill of Rights? And if so, doesn't that tell us something about the problem of delegation of Article 3 power, quite independent of the Bill of Rights?
I'm not understanding the question, but I think the answer would have to be the same as public and private rights. I think for private rights is where you are guaranteed an Article 3 judge, at least at some stage. Now, it's true we allow for you to have not an Article 3 judge at some stage, but ultimately an Article 3 judge does have to come into the picture. And I don't know of any international institutions where they say, we'll give you an international hearing first, subject to appeal to United States Court of Appeals for DC. But so to the extent that it's a private right, you need an Article 3 judge at some point. But let me say one final interesting thing about the Article 3 thing. In the context of the slave trade dispute, the slave trade court dispute, they didn't like the slave trade courts, and they had a strong feeling that they were unconstitutional, which they were trying to figure out how to explain, and they offered a laundry list of reasons why they were unconstitutional. Some more convincing than others. What I find fascinating, because it's clear they were trying to think of every possible reason. No one suggested, they said, they're foreign courts, but with the brief exception of a quick suggestion by William Wirt that no one really bought. So William Wirt briefly suggests they're foreign judges, but no one really picks up on that concern. And when you think about it, it's actually quite interesting that Article 1 and 2 require U.S. citizenship for legislators and the executive, but I hadn't thought about this before. There is no actual requirement of citizenship for judicial officers, and one reason. So that may actually make us think at first that international delegations maybe are more okay in the judicial setting. But then there's the other side of the coin, which is judicial officers are also different from Article 1 and 2 in that they are non-elected by the people. So you think the people, they may be stupid and vote for some kind of Bonapartist or monarchist, and you need to make sure that they're really an American citizen. But once you have the president picking them, and the president was born in America or is a naturalized citizen, and the Senate confirming them, that really takes care of the issue. That may be the answer. So if that's the reason, if that really fills in the citizenship requirement for Article 3, then situations where the particular judges are picked by a complicated mechanism using the General Assembly may not fully satisfy that concern.
So I just have to jump in and say a little bit here, even as the moderator. First, I think the public-private rights distinction, even in the Supreme Court cases in that line of reasoning about what powers can be delegated to Article 1 courts, that is, courts set up by Congress but not subject to the strictures of Article 3 in terms of life tenure or confirmation. I think most commentators have said that whole line of cases is a complete mishmash in terms of its reasoning and analysis as to why the public and private rights distinction should make a constitutional difference in terms of Article 1 courts, and the cases are somewhat incoherent in their theory. Second of all, I think it's important to note that even within our constitutional system, independent of that public-private rights debate for Article I courts, we allow non-Article III courts to hear many private rights disputes, that is to say our entire state court system, which the Constitution not only tolerates, but many Federalists might say sort of encourages. So states are free to hear criminal cases or civil disputes, and they don't have to follow the constraints of Article III in the way states set up their court systems. We allow, as Oona pointed out, arbitration in private commercial bodies. That is, parties can agree by contract to submit their private disputes of a classical private rights nature to non-governmental entities entirely, and then have those decisions of the non-governmental entities enforced in the federal courts or in state courts without any scrutiny of the decision-making process. And we routinely have allowed the extradition of defendants in criminal cases to other countries. That is to say, we extradite people to countries without jury trials, send people to France for trial all the time. And that has been true for our entire history. So I just want to throw all those things in as complicating factors that a simple allusion to the private-public rights distinction doesn't quite capture.
So the panel all seem very surprisingly in accord, and in particular, they all say that we should calm down about the sovereignty problem, and that the hysterical quotes that Oona put on the board for us to mock are not very sensible. But I wonder, it seems to me you've all provided very good reasons why much of the international order doesn't, as it now exists, doesn't seem to be a serious problem for sovereignty. But the very fact that those reasons are good suggests that the absence of the factors you point to might create a problem. And I'm wondering if it might be that some of those historical voices are keeping us from entering into schemes that even you would say violate sovereignty, or at least something important about our independent constitutional order. And so Oona, for example, says that most of the bodies enforce their norms through outcasting. And I thought that was a very persuasive point. I'd never thought of it that way before. And it does seem quite reassuring that our sovereignty can scarcely be invaded by other people deciding not to let us have the benefits of their club, right? That seems right. But the flip side of that is there must be international bodies that enforce their norms in some other way, which is troubling. And so I would wonder, is that so? And should we sort of have a checklist of sovereignty troubling sorts of things, and one of them might be enforcement through non-outcasting norms. And John McGinnis talks about the ex-ante protections where the international body makes a decision, but that the domestic institutions have to actually institute them. That sounds like the language from yesterday of non-self-executing treaties. I don't know if that's exactly parallel or not, but it raises the question, well, what about bodies, international bodies whose decisions do have direct effect in the United States without these ex-ante mediating protections? And Eugene speaks of the fact that there have never been, that there were 3 serious proposals in history, but none of them adopted for judicial type international processes that would have direct effect in the United States. Well, what if some of them were adopted? The International Criminal Court, for example, which had a lot of political support, could have been adopted. So what happens? Would you all agree that, and one other thing I thought was very important is the ability to withdraw. Both not just the juridical ability to withdraw, but the practical and pragmatic ability to withdraw also is a huge protector for sovereignty. But what should that tell us that we should be worried and maybe even hysterical about international bodies where we can't practically withdraw, where their decisions would have direct effect within the United States, and where their enforcement mechanisms are something other than outcasting.
Yes. Let me say one thing about worrying. I don't want to suggest that one shouldn't worry about these kind of delegations. I would suggest that the nature of the worry may be should be about more cultural than political or legal. That is to say, as I previously mentioned, there's a flip side to the hysteria Professor Hathaway mentioned, which is international organization mania, or that is to say, just like one can overestimate the dangers of joining these things, one can greatly overestimate the benefits. I think this is actually very much related to a parallel discussion about the use of foreign law and constitutional interpretation. And it's very easy to make fun of criticisms of the use of foreign law, because foreign law has been used in so many ways, it's used all the time, there's a long history of it, why are people all of a sudden concerned now? I think the real source of the concern is a kind of cultural concern that some people may take the use of foreign law or convergence, legal convergence, as a good in itself, or greatly overestimate the value of that good. And similarly, there might be a concern about overestimating the value of institutional convergence that might make people willing to accept too great political costs on the other hand. And what has happened in Europe, when we talk about convergence in international institutions, I think Europe is the dominant example. We see in much of the rest of the world the dissolution of federative nations, the dissolution of small nations. We see vast increases in secessionist tendencies and generally the desire of states to go, small groups to want to go their way rather than be part of something bigger. Europe is the dominant example on the other side of it, and I think that's due to a complicated set of cultural and historic changes and attitudes. And if you want to be concerned about it, you have to just think about the nature of public sentiment, public discourse, and those will be the greatest protections.
I think you ask a good question. I guess I would start by saying that one of my central concerns is that the legitimate question you ask is one that people tend to blow these, what I think are quite limited sets of real worries up to the point where they then are suspicious of international bodies as a general matter, and that leads to, I think, unwillingness or suspicion of joining international bodies that are ultimately much more quite beneficial. And that's my idea of voluntary outcasting, right? That you're choosing not to be a part of an organization, therefore losing access to a lot of things that we might want to be a part of. But let me take your particular questions in turn. So you asked about direct enforcement of judicial decisions. Should we be worried about that? And I guess, so first of all, we've talked a lot about, in many cases, the kind of political checks have been sufficient to address what might be any real concerns. The main one, as I mentioned, was the New York Convention on Arbitration. Should we be worried about that? Well, I mean, you have to remember that in that case, you have private parties who've agreed to bring something to a private arbitral panel. They've agreed to be bound by the decision of that private arbitral panel, and that arbitral panel then makes a decision, which then is enforced in U.S. courts. And it's enforced against the private party that agreed to be bound by this separate process, in addition to the fact that the United States has itself agreed to join this international regime that provides for direct enforcement of those commercial arbitral decisions. And you might say, well, isn't that usurping the judicial power, because effectively you're making U.S. courts into kind of the arm of these private organizations? Well, maybe, but on the other hand, remember that you then have access to, anytime you get an arbitral decision that favors a U.S. citizen or U.S. corporation, it can be enforced anywhere in the world that has also joined the New York Convention. And frankly, I think that U.S. benefits much, much more than we might might be harmed by this, and that's why we continue to be members of it. So, do I think that raises sovereignty concerns? I don't actually think so, even though that does provide for direct enforcement of decisions by arbitral panels that are effectively operating just as courts would. On your question about withdrawal not being possible, Yeah, I've written about this totally separately. There was a volume put together by Kurt Bradley on international delegation that might be sort of interesting to you. But one of the questions I asked is exactly what you said. What if withdrawal is not possible? I think, again, the first thing I would note is that that's rarely the case. In most cases, there is instant withdrawal. In other cases, there's sometimes delayed. And so you may be out of compliance with your international legal obligations as a result, and there may be consequences for being out of compliance with those international legal obligations, but those wouldn't be able to be enforced directly in U.S. courts. As a matter of U.S. law, it would no longer be enforceable once we've withdrawn, either through last in time or through the president signaling withdrawal. So again, I don't see that as a significant imposition on sovereignty for those reasons. As to non-outcasting enforcement, we do talk about that in our paper. It's surprisingly a small portion. And once you start looking for this, maybe it's like I've got a hammer, everything looks like a nail, but I don't think so. I think it's one of these things that really so much of enforcement is operating through outcasting. There are some instances of non-outcasting enforcement. One of the key examples is the NATO response force. So this provides for an actual army under the control of NATO, which then is capable of carrying out some of the particular roles of the NATO organization. Frankly, most of the instances that you could find where there are international organizations that provide for mechanisms of enforcement that are not done through outcasting, the United States is usually leading the charge. It's usually, so NATO, obviously, perfect example of that. Counterterrorism and self-defense. U.S. is the one with the drones running around the world. So if there's a source of problems, we may have to look at ourselves more closely than international bodies.
Well, I just want to restate my position because I think maybe I wasn't clear. The ex post is actually ex post that a treaty would be non-self-executing. That gives an ex post protection because then you have to bring it over into domestic law. For instance, the WTO is an excellent example. It makes decisions under international law. There can be, as Oona now, this wonderful new word, outcasting and constraints in that way, but there's no domestic effect unless Congress agrees. So that's an ex post constraint. The ex ante constraint is the 2/3 requirement of the treaty clause. I think that is an extremely powerful constraint, and particularly if people are clear about the fact that there's a delegation going on here. And I think that was the issue in the Medellin case. The Supreme Court said that you actually have to be clear if we're going to answer to Professor Childress's question, if you're going to actually give interpretive authority to an international court, it not only has to be a treaty, it has to be clear that the Senate is voting this. I think that's a very powerful constraint as a practical matter, particularly in a world of American, a sense that we have of American exceptionalism. And the evidence I would point to that is is the complaints. And Professor Hathaway, in this sense, is in a long tradition since, I believe, Woodrow Wilson, who's complained about the substantial constraints that you have to enter into treaties and suggested that maybe we can have congressional executive agreements to interchange with that. My position is that's the protection that we should not allow, certainly with respect to delegation, the alternative of congressional executive agreements, which don't have to reach that high hurdle. So as a practical matter, I'm less concerned because of voting rules. And that, I think, is in general a great deal more protection against something you're concerned about than mere parchment barriers, to go back to some kind of structure in which it's all about rights or protecting about, we're going to have the Supreme Court protecting some set of rights. If we actually just focus on requiring that it be done within a treaty, I think you have very substantial constraints on the kinds of delegations that can get through the United States Senate. And again, there's a huge amount of evidence, even treaties that don't delegate a lot of things, like international human rights treaties, the United States doesn't ratify them because we cannot get that requisite majority, even when many other nations of the world do. So I think we have a substantial protection ex ante against these delegations that may be the most important consideration in thinking about this question.
All right, I think our time is up. I want to thank the panel for a lively discussion, the audience for its questions.